Hello friends, welcome to Delhi Law Firm, your trusted legal partner. If you are an NRI or planning to marry a foreign national, this information is extremely important for you. Marrying an NRI or a foreign citizen in India is completely legal and valid, provided you follow the correct legal procedure. Many people are unaware that an NRI marriage can be solemnized not only in India but also abroad and still be legally recognized in India. Today we will explain in detail how such marriages are conducted, what documents are required, and how you can obtain your marriage certificate on the same day. To begin with, it is important to understand that NRI or foreign marriages in India are governed mainly under three legal frameworks: Foreign Marriage Act 1969, Special Marriage Act 1954, and personal laws such as Hindu marriage, Christian marriage, or Muslim nikah. Each of these ensures legal validity, but proper documentation, attestation, and apostille verification are mandatory for recognition. If the marriage is taking place outside India, the Foreign Marriage Act 1969 applies. Under this law, every Indian embassy or consulate abroad has a designated marriage officer. When an Indian citizen or NRI wishes to marry another Indian or a foreign national abroad, they must first submit an application at the Indian embassy. Along with the application, both parties must provide their passports, visas, birth certificates, and a single status certificate or marital status certificate. The marriage officer then issues a 30-day public notice. If no objection is raised during this period, the marriage is solemnized and registered at the embassy or consulate in the presence of 3 witnesses. The marriage officer then issues a marriage certificate, which is legally valid under Indian law. After the marriage is solemnized abroad, if you wish to have that marriage legally recognized in India, Delhi Law Firm assists you in completing the apostille and attestation process. Apostille is an international verification procedure recognized under the Hague Convention of 1961, which validates your marriage certificate for use in both India and the foreign country. Attestation refers to the endorsement and authentication of your documents by the Ministry of External Affairs (MEA) and the concerned embassy, confirming that the marriage is genuine and legally valid. Once this process is completed, your marriage certificate becomes acceptable for all legal visa, passport, and property-related purposes in India. Now let's discuss NRI marriages, where one partner resides in India and the other abroad. Such marriages can take place in 2 ways. The first is when the foreign partner travels to India and the marriage is solemnized under the Special Marriage Act 1954 or through any religious procedure such as Arya Samaj marriage, Christian Marriage Act 1872, or under Muslim law nikah. The second method is when the marriage takes place abroad and is later registered in India under Indian law. If the marriage is being conducted in India, Delhi Law Firm assists you with all the documentation. A foreign national must submit an embassy NOC, no objection certificate, and a single status certificate before the marriage. Along with that, copies of the passport, valid visa, address proof, and identity documents of 2 witnesses are required. Both parties must sign affidavits confirming their consent and marital status before the marriage officer. Once this is done, the marriage is solemnized before the marriage registrar and the court marriage certificate is issued the same day. This certificate is legally valid across India and can also be used abroad for visa or spouse visa purposes. If the marriage is conducted according to Vedic rituals at an Arya Samaj Mandir, it is also fully valid under Indian law. For more information, visit aryasamajmandir.in. After the ceremony, the Arya Samaj certificate can be registered before the marriage registrar and a court marriage certificate can be obtained on the same day. This is a government-approved and legally valid document. For NRI or foreign citizens, Delhi Law Firm ensures that all documents are in the correct format, properly verified by the embassy, and free from any errors. Our team handles the complete process of apostille, attestation, notarization, and legal translation in accordance with international legal standards. If the marriage is conducted under the Special Marriage Act 1954, there is usually a 30-day notice period. However, through Delhi Law Firm, if all documents are pre-verified and complete, the marriage can be registered before the marriage officer on the same day in the presence of witnesses. This law is particularly useful for interfaith or international marriages. For example, if one partner is an Indian Hindu and the other is a foreign Christian or Muslim, the marriage will still be fully legal and valid in India. In both foreign marriage and NRI marriage cases, certain documents are mandatory. passports of both partners, visas, birth certificates, single status or divorce certificate, embassy NOC marriage application form, identity proofs of witnesses and photographs. All of these must be attested or apostille before submission. Delhi law firm handles this process step by step, ensuring that you only need to appear once and receive your certificate on the same day. Delhi law firm also ensures that your marriage certificate, after verification by the Ministry of External Affairs (MEA) and the relevant embassy, is digitally verifiable on the official Government of India portal. This allows you to use your certificate for any official passport or consular purpose without difficulty. Once the NRI marriage is registered, both husband and wife enjoy several legal rights. The marriage certificate acts as conclusive proof of the marital relationship. It is essential for foreign travel, spouse visa applications, property transfers, insurance claims, inheritance matters and maintenance or custody cases. In case of a future dispute, such as divorce, custody or property conflict, this certificate serves as primary legal evidence in court. Delhi law firm not only assists with marriage registration, but also provides complete legal support for post-marriage issues including NRI divorce, child custody disputes and property rights. Our expert legal team ensures that all affidavits, certificates and documents are prepared as per international legal standards so that your marital status is legally recognized globally without any challenge. In today's times, when many fake agents and unauthorized centers issue fraudulent marriage certificates, it is extremely important to rely only on authorized and lawful procedures. Delhi law firm guarantees that every step of your process, from documentation and verification to marriage registration and certificate issuance, is handled transparently, safely and strictly under government regulations. So, if you are an NRI planning to marry a foreign national or wish to register your foreign marriage in India, Delhi law firm provides a one-stop legal solution for you. Our professional team simplifies every step: embassy coordination, apostille attestation, marriage registration and certificate issuance, ensuring a smooth, efficient and stress-free experience. At Delhi law firm, our goal is not just to solemnize a marriage, but to legally protect your relationship and grant it international recognition. Your marriage is not merely an emotional bond, it is also a legal commitment that deserves proper documentation and legal registration. So, remember, whether you are in Delhi, Dubai, London or New York, Delhi law firm ensures that your marriage is fully valid, secure and legally recognized under the eyes of Indian law. Your marriage, our legal guarantee. For more information, visit courtmarriage.in.